Hi, friends. Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today.
As the prosecutor finished, she said, "This is shocking, unthinkable." I believe there were other words used throughout trial. Unbelievable. Obviously, unbelievable, unthinkable, unfathomable. And the reason that's the case is because it was unforeseeable. No one expected this. No one could have expected this, including Mrs. Crumbley. Now, the first thing I want to do very quickly is talk to you about the burden of proof. In the state of Michigan, there are different burden of proofs depending on what kind of a case it is. When people sue for money and say, "I've been injured," or "I was failed by the school," even, there will be civil lawsuits, and the burden of proof is a preponderance of evidence. That means it's about a 50-50 standard. And if you have 50% of the evidence, that's the burden of proof for civil. When the state thinks it's important to take away a person's children, the burden goes up, and the burden has to prove more evidence, and that specifically is clear and convincing evidence that it's correct for the state to be taking away a person's children. Now, the highest burden in this country is in a criminal case, and that is beyond a reasonable doubt. And the reason I'm telling you about the differences in the burdens is because in a criminal case, if you have just one reasonable doubt about the case, you must vote not guilty. And so this is my poster just showing beyond a reasonable doubt is guilty, but there's many, many other options. If you think it's likely, probable, possible, not likely, those are all not guilties. You have to be sure beyond a reasonable doubt. And later, as I go through my closing, I am going to tell you the reasonable doubts that the defense believes exist in this case for you to look at. The other thing I have to ask you to keep in mind is that in the jury instructions, and I think you've been told this throughout trial, the defense does not have to prove or do anything. Like Judge Matthews said, we could sit at the table and play chess the whole time, call no witnesses, cross-examine no witnesses, provide no evidence, because we have no burden to prove a thing. However, in this case, you obviously saw the defense present Mrs. Crumbley, who took the stand, so that she could give you some context beyond parts of the evidence that were confusing when the prosecutor was introducing in bits and pieces. And the problem in this case is that we can all agree everything can be seen different in two ways. First of all, when you look back in hindsight with 20/20 vision, when you look back in hindsight, it is easy to say, this could have been different, that could have been different, this would have changed. And the other circumstance, the second one that makes a huge difference, is when you get full context around the evidence that is being used. And in this case, the prosecutor has cherry-picked little bits of evidence out of mountains of evidence to put in front of you with no context to explain what they're doing.
Okay, other than getting the standard in a civil case wrong, it's 51%, not 50%. If I only establish it's possible, then I don't win. I have to establish it's more likely than not, and that's 51%. But since the prosecution didn't object to that, it's an improper legal standard, and that would have been the proper objection. It doesn't really matter, other than the fact that people like me who are law nerds pick up on that kind of thing. I think this is a fairly good start to her closing argument, reminding the jury what their job is, reminding them that, if there's any reasonable doubt, they have to acquit, and then pointing out that there's mountains of evidence and they only got just a few cherries off the tree. All of those are an excellent way to start. Let's see where she goes with this.
find, and I know the prosecution takes issue with this one, that Mrs. Crumbley was actually, in fact, a hypervigilant mother. She's the kind of mother who is going to the friend's mom to chase down why he's having a moody and kind of depressed day. She's on Power Schools on the app multiple times a day checking for missing assignments. She's emailing teachers about grades. Christy Gibson Marshall, the assistant principal, who did do one of the bravest things I've ever seen, she testified she saw the shooter's face and couldn't believe it was him. And the reason she couldn't believe it was him is because it was so unforeseeable. Mrs. Crumbley's hypervigilance also comes when you look at how she takes him for medical appointments. They're at the urgent care because some little mole on his back changed colors when she's applying sunscreen. I think of myself as a hypervigilant mother, and I've never noticed any moles on my kid's back, and I must need to go home and look. Because when I look at the actions of Mrs. Crumbley, she actually pays far more attention to that kind of thing and other things than I do.
Well, I guess I'm glad to see that she has children, but I don't think that is going to have a great deal of impact on the jury right there, because she has kind of come off as flighty and unprepared and unprofessional, and she's had a lot of problems during the trial. She's making some good points, but she probably should have left the personalization out of that one.
The final date that the state claims Mrs. Crumbley had knowledge about back from March of 2021 are exhibits 96 through 100. And 96 starts off with their son saying, "I'm picking up the room. I cleaned until the clothes started flying off the wall. This stuff only happens when I'm home alone. I pick the clothes back up though." And that's the important part of those texts on the 20th. We know on that date, because the people proved it, no pun intended, but they beat a dead horse, that at 97, it's a picture of Jennifer at the barn. We've got the metadata showing Jennifer was at the barn. We've got another picture on 99 showing Jennifer was at the barn. And exhibit 100, Jennifer was at the barn. Big deal. Jennifer's at the barn. Their son is saying goofy stuff. Jennifer gave you the context. They had an Ouija board for a couple months after Christmas of 2020. He and his friend are playing with the Ouija board. They ultimately lost interest. They stopped doing it. Jennifer admitted to you one day to mess with them. She turned the power off in the house, turned the circuit off to mess with them. She mentioned a time where James pretended he was getting electrocuted. She didn't know what to do. She's screaming, trying to kick him, see if he's electrocuted. Ethan is laughing, taking a video of the whole thing. This family played together. They had fun. They did what families do. The prosecution just had zero context because they had tunnel vision that she was doing something wrong and was grossly negligent, and they were hell-bent on convincing you that was the case.
I do think the prosecution has gone overboard in proving certain things in this case. As she points out there's 6 different exhibits that basically show the same thing. You don't need to do that, and it's disrespectful to the jury. And in fact, most of it should have been objected to as cumulative and kept out of evidence. But in this case, it was probably a pretty smart move to allow them to make an idiot out of themselves by putting all this evidence in. She's doing a good job of contextualizing all of the things that happened in this case and making some of that evidence, which was really kind of weird to be in there in the first place, make some sense. So again, she's doing what a good defense attorney would do. She's saying, look, there's other ways to look at this evidence. You can't necessarily assume that what the prosecution is telling you is the exact right way to do it. simply because they weren't there. They didn't see it. They weren't there 24/7. There are no cameras in their life that are giving them a 24/7 view. No, what they're doing is they're picking and choosing information that makes her look bad in order to convince you that she's grossly negligent. And the stuff that makes her look bad, her being on a horse, has absolutely nothing to do with her being negligent. The fact that the kid is acting like an idiot because he played with a Ouija board, again, it's stupid, but does it establish that she's, negligent? I don't think so. So she is making some good points here with this jury, I hope.
Where the prosecution had him testify that Mrs. Crumbley said to delete his messages, clear your cache. And I'm so thankful that the rest of the world sent me emails that I don't know how to pronounce cache, because now I do. And when Brian ended up seeing the messages before clear your cache and after clear your cache, he realized, oh, she wasn't asking me to delete messages. She wanted me to refresh my web browser to see if the Facebook had actually deactivated. And so that was proof again that when you have more context, you're more accurate. And the problem the prosecutor has in this case is they have very little context for the very little evidence they've submitted. There's also no context around some of this little bits and pieces of useless evidence, like Jennifer Crumbley saying that her son was an oopsie baby. I call my son that, so what? Does that mean I hate my son? Does that mean I would be okay if he went and killed a bunch of people and or if he committed suicide? No! Calling your child an oopsie baby was designed to try to make her look bad with no context. Having Amanda Holland come in, a coworker who's not a friend to Jennifer Crumbley and has been interviewed by law enforcement to tell you her advice on she should go have a mother-son day with her teenager, so irrelevant when she's faced with raising toddlers every day. When I heard her advice, I thought, yeah, right. I have 3 teenagers. I almost have a 4th. And personally, not only would they rather do anything else than spend a day with me, I'd rather do anything else. And we do spend time together, but that's not their first priority when they get to pick what they're going to be doing.
So far, I haven't heard her say very much about intervening clause, and I think that's probably a mistake. But trial strategy is what trial strategy is, and I'll have to wait and see if that's what she should have done or not. I think it would have been a reasonable thing to argue here that the prosecutors had I think it would have been a reasonable thing to argue here that the school counselor and the dean had the last clear chance to stop this, and they didn't take it. And they were negligent in not searching the bag. They were negligent in not looking at that and saying, he's drawing a gun. Let's see if he has a gun. I mean, that's the reasonable thing to do. So I'm not sure why she's not arguing that. Maybe because she was there and she saw the pictures too. Maybe they could argue that, she had just as much responsibility as the school counselors did. But school counselors knew what a target-rich environment that school was. So I think overall, I would give her a B+ on this. I think she's done a fair job. Her voice is terribly annoying to me. It's like fingernails on a chalkboard. And she has an annoying habit of waving her card around when she's presenting to the jury, which can be very distracting. She needs to work on her presentation skills. She should have gotten herself a good copy of PowerPoint to use the way the prosecution did. It would have been much more effective. But my guess is she doesn't have somebody who can sit down and teach her how to go through all of that and how to work with it at trial. If she did, she'd probably do a much better job on this particular closing. But what she's done is a B+ effort, and I think that the case is stronger for the prosecution in many ways, but she had a lot to argue, and she did a good job of arguing it. So now it's handed over to the jury, and we'll see what the jury has to say. Thank you so much for watching. If you have an opportunity today, go out of your way, do something nice for somebody, and then Come back here tomorrow and catch me at the beach. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.